Now, we have read in preamble that the was resolution of insolvency in a time-bound manner. So time is very important as far as insolvency proceedings and IBC is concerned. So the entire CIRP process, as per the code, section 12, has to be completed within a period of 180 days, including, so it does not say 180 working days. It is 180 running days. So the moment the application is admitted and the company and corporate insolvency resolution process starts, the countdown period of 180 days start ticking. There is absolutely no holiday which is prescribed under IBC. Saturday, Sunday, all holidays, everything is included within the period of 180 days. However, this period of 180 days could be extended by another period of 90 days if the COC passes a resolution to that effect and gives 90 days, which this extension can be granted only once by the adjudicating authority on the basis of an application to be filed by the RP before NCLT with 66% approval of the COC members. However, there is another rider. It says that in any case, because this makes up 270 days. So there was an amendment which says that in any case, the time period should not go beyond 330 days, including the judicial time. So as it stands today, once the company is admitted under IBC, it has to be resolved within a period of 330 days, including the time taken in judicial proceedings. Now, section 7 deals with application which may be filed by the financial creditors, the FCs. It says section 7 provides that a FC either by itself or jointly with other financial creditors. Now, this is for the very first time where powers have been given to multiple financial creditors. Multiple lenders can file one common application to start CIRP proceedings of a company. So suppose there are 5 financial creditors and each financial creditor owed an amount which is less than rupees 1 crore. So they jointly can file an application and get the threshold limit of 1 crore and start corporate insolvency resolution process of a company, even if their individual default may be less than rupees 1 crore. Default means non-payment of debt when whole or any part or installment has become due and payable and is not paid by the CD. So again, we come back, there is no concept of NP under IBC. It is only a single default which may take a company under the provisions of IBC. And section 7 does not provide for giving any demand notice or prior intimation to the corporate debtor before filing of section 7 application. Under provisions of 138 Negotiable Instrument Act, whenever there is a check bounce, a notice is mandatorily to be given before case could be filed before the court of MM. However, under section 7, there is absolutely no need as far as the financial creditors are concerned before filing application. This means the government wants, the parliament wants that each company must be aware about its liabilities, and they should act in a professional manner, and they should timely pay their interest and installment dues. In case they are not able to pay the dues, the company is eligible to be admitted under the provisions of IBC. Whereas under section 8 and 9, when an operational creditor has to file application for initiation of CIRP proceedings, a demand notice is mandatory. The operational creditor has to give a 10 days demand notice in advance before filing the application, calling upon the corporate debtor to pay the amount or to reply to the notice, raising a default which must be in existence prior to issuance of section 8 notice. So what we have experienced all these years, when we file recovery suits, the basic defense which a debtor raises is with respect to the quality of goods. Suppose goods are supplied in the year 2021, the recovery suit is filed in the year 2020-23, even after 2 years. The basic defense which most of the corporate debtors take is that the quality of goods was not proper. However, in most of the cases, no demand notices, no procedure as contemplated under Sales of Goods Act when the goods are defective are undertaken by the corporate debtors. So the Parliament wants that these companies, their corporate debtors, must act in a professional way if there is any genuine dispute because of which payments have not been made to the creditors. The disputes must be raised as per the provisions of law, either by filing of cases or by sending email, whenever the mechanism is available. But simply when a creditor files a case, issues a demand notice demanding the money, a corporate debtor cannot come up and say that the goods supplied to me or the services availed by me were not proper. So the dispute, it says, when the reply is given, the dispute must be pre-existing. That is, the dispute must be in existence prior to the date of issuance of demand notice. Only then it could be taken as a valid defense to the application filed by the OC. Otherwise, it will be treated that it is an afterthought, a moonshine defense which has been raised only to avoid admission of application under Section 9. So the corporate debtor must thereafter, within 10 days of the receipt of demand notice, bring to the notice of the OC the existence of a dispute, in case there is a dispute, if any, and record a pendency of suit or arbitration proceedings filed before the receipt of such notice or repayment of unpaid operational debt. So the other option available to the CD is, he could either pay the amount, he could say that I have already paid the amount, or there has to be a pre-existing dispute. If the amount is not paid within 10 days, the OC can file application under Section 9 before the adjudicating authority, that is National Company Law Tribunal. The adjudicating authority within a period of 14 days must admit or reject the said application. So the time period is given, 10 days demand notice is given once the default occurs, and once the application is filed, the adjudicating authority has to take a call on it within 14 days. If the application is admitted, immediately upon admission of application, the management will lose its control. The directors, the board of directors will get suspended. And it is very important to note that the directors remain, but only the board of directors get suspended. So the directors still remain, and they have to cooperate with the IRP or RP who is appointed. It's only the board of directors which gets suspended. No decision can be taken by the board of directors thereafter. Section 10. This section enables the corporate debtor itself to file the application for CIRP proceedings, where a corporate debtor itself feels that the corporate debtor is not in a position to repay its debts, and no creditor is coming forward to initiate the CIRP proceedings. The corporate debtor itself can file an application with the adjudicating authority for initiation of CIRP proceedings. But under Section 10, for initiation of CIRP proceedings, we must understand that as it exists today, the provisions of winding up of a company are no more in existence under the provisions of Companies Act on the ground of non-ability of companies to repay debts. So only route available for companies to wind up. So winding up word has been now changed with liquidation under the IBC. So today, if a company wants to close down its operations, the only option available is under the provisions of Insolvency and Bankruptcy Code, either by going through CIRP proceedings or by filing for voluntary liquidation. Now, once the application is admitted by the adjudicating authority, immediately upon admission of application, the application could be admitted under Section 7, filed by financial creditors, under Section 9, by the operational creditors, or under Section 10, by the corporate debtor itself. So what are the immediate implications upon admission of an application by the adjudicating authority? So the first and very basic implication is that the powers of board of directors of the CD are immediately suspended. So powers of board of directors are suspended, but the directors remain. So we must understand that it is not the directors who get suspended. Only the board of directors get suspended, as opposed to disqualified directors, which only ROC can do in certain cases upon non-compliance of filing of statutory returns or other conditions. So under IBC, the board of directors gets suspended. The IRP takes control and custody of all the assets of the corporate debtor. So whatever assets are in the name of the corporate debtor, be it the registered office, the stocks, the bank accounts, the investments, the vehicles, the factory premises, Everything is now under the control of IRP, RP. And IRP, RP is nothing but the insolvency professional appointed in most of the cases by the creditors of the company. So by these two provisions, we understand that the debtors lose the control. The board of directors, the management loses the control of the company, and the control gets shifted to the creditors acting through IRP or RP. Now, the duty of the RP is to keep the corporate debtor as a going concern. Now, this is also a very new concept to India. Under SARFAESI Act or under normal recovery certificates issued by the courts or arbitration proceedings. What we used to do till today is we used to, under SARFAESI Act, bank used to take physical possession of a running unit. The bank would put its seal over that premises, over that factory premises, and will sell it on a standalone basis as a defunct unit. But IBC gives a different way of recovering the money, because the basic purpose is revival of the unit. The basic purpose is that suppose a big unit has come into existence, lot of resources, lot of employment get affected when a unit is closed. So the duty has been cast upon the RP to keep the CD as a going concern. So it simply amounts to change in management. If we understand in simple terms, the board of directors, suppose a company is sold by an old management to a new management, the company remains a going concern. So even under IBC, even though the powers of board of directors got suspended, the business operations, day-to-day operations of the corporate debtor are not to be stopped. It is the duty as well as the responsibility of the RP to keep the corporate debtor as a going concern. Especially we have seen in the case of Bhushan Steel that the company was kept as a going concern for the entire period. Another example is Jet Airways. The operations of Jet Airways were closed before the CIRP proceedings started, but the RP kept the company alive. The company was not totally wound down, and ultimately a new management has been inducted. So RP is to constitute a committee of creditors. A committee of, since the board of directors have been suspended, a new committee of creditors. So the creditors will now there are certain actions which the RP will do, and the committee of creditors will approve or authorize the RP to do certain acts for the revival of the company. Because ultimately, it is the creditors who are the biggest stakeholders in any corporate entity. RP to prepare information memorandum. Now, this is one important document. Information memorandum is basically the details of the company, all the details of the assets and liabilities of the company, of the corporate debtor as on CIRP commencement date. Now, this information memorandum is the basic document on the basis of which plans are invited from individuals, from other corporates who are interested to restart the corporate debtor, who are interested to invest money in the corporate debtor so that it could be revived and resolved. And the last and most basic function is to invite resolution plans. Resolution plans are basically plans given by these plans in case the corporate debtor is a MSME having a registration certificate. In that event, the directors are also qualified to give their resolution plans for the corporate debtor. In case the company is not an MSME, the directors cannot give any resolution plan. They are debarred under section 29A of IBC. So it is very important that all the corporates must obtain a certificate of MSME, apart from other benefits which the government is giving. Even under IBC, the company, if a company is under stress and they are MSME registered, so the directors themselves can give a resolution plan suggesting ways to rebuild the company by infusing fresh funds from other entities and getting back control of their own company. Now, during this process, a moratorium is imposed under section 14. Basically, moratorium is given as a cooling off period. When the company is under stress, a lot of litigations are filed under the company, and the management is busy dealing with those litigations, which may be at advanced stage. So under section 14, once a company is admitted under CIRP proceedings, no civil proceedings under any law can continue or could be filed against the corporate debtor. Even if there is a decree which is passed against the corporate debtor prior to CIRP commencement date, that decree cannot be enforced. No fresh civil litigation could be filed. No income tax proceedings, GST proceedings, or any other proceedings could take place during the moratorium period. The moratorium period starts on the day when the petition is admitted under Section 14, under Section 7, 9, or 10. The basic purpose is to give a calm period to the IRP, RP, so that he could collate all the claims against the company, he could get control of all the assets of the company, and he could invite resolution plans. He is not to defend the various pending litigations under various civil laws. However, this moratorium is not applicable to criminal proceedings which may be initiated by the police or any other government authority against the directors. So it says, on the insolvency commencement date, the AA shall declare a moratorium for prohibiting all the following: the institution of suits or continuing of pending suits or proceeding against the corporate debtor, including execution of any judgment, decree or order in any court of law, tribunal, arbitration panel, or other authority. It also prohibits the corporate debtor from transferring or encumbering, alienating, or disposing of its assets or any legal or beneficial interest to any third party after CIRP commencement date. So all the assets which are in the name of the corporate debtor as on CIRP commencement date shall and will remain in the name of the corporate debtor, and they cannot be sold. No legal proceedings could be filed or continued. It further goes on to say that no any security interest created by the corporate debtor in respect of its property, including any action under SURFACI Act 2002. So even secured financial creditors cannot proceed further under the provisions of SURFACI Act for recovery of their dues. So the entire recovery proceedings, entire civil proceedings against the corporate debtor comes to a standstill. The recovery of any property by an owner or lessor where such property is occupied by or in the possession of the corporate debtor. So a landlord, suppose a factory of a corporate debtor is running on a tenanted premises, even the landlord cannot get back his premises. There is a moratorium against the landlord, and the corporate debtor can use the premises even during the CIRP process period. The supply of essential goods or services to CD shall not be terminated or suspended or interrupted during moratorium periods such as electricity, water supply, internet, telephone. But we must understand that these essential supplies could only be continued if they are not the input for the corporate debtor for the material which the corporate debtor is selling. Suppose electricity is a basic input. There is industrial electricity, industrial power that is being used. So moratorium will not apply to that. It is only for office electricity, water supply in the office, internet and telephone for office use. But suppose a corporate debtor is into telephony business, then this moratorium will not apply, and they would require to pay the supplies during the CIRP period also. The moratorium is not applicable to a co-borrower. So this is very important. There was a confusion earlier. This moratorium is only with respect to the assets of the corporate debtor. This moratorium will not apply to the co-borrower or surety or guarantor or mortgager or their mortgage assets. So there is no moratorium applicable to guarantors or sureties. It is only and only for the corporate debtor. The assets which are in the name of the corporate debtor, they cannot be liquidated. But banks and financial institutions or other creditors are free to initiate recovery proceedings against the individual guarantors.